Hi, everybody. Thank you so much for joining our webinar on the NPRM provisions on providing equal access to stable, high-quality childcare for low-income children. We're very happy to have you, but we had high registration numbers for this one, so we're going to give folks just a few more minutes to log in, and we will get started in the next couple of minutes. Hi, everyone, and thank you again for joining our webinar today on providing equal access to stable, high-quality childcare for low-income children, particularly related to the CCDF 2015 NPRM. I'm going to give you just a few quick logistical announcements, and then we will get started. First of all, you've likely noticed that your phone is muted. It's so that we can avoid having any background noise, but if you have questions or comments throughout the webinar, feel free to chat them in. It's worth noting that any comment you send us over the chat box does not count as an official comment on the NPRM. Also, we are not anticipating that we'll have a lot of time, if any, for questions today, but it is helpful to have the questions regardless so that our policy team knows what folks are wondering about in the field. And finally, we will inevitably get a question about whether or not the slides are available. They are not currently available, but it is our hope to have this webinar and the slides associated with it posted on the OCC website within about the next week. When we have that posted, we will send a message out to everyone to let you know that it is available and where it is available. So without further ado, I will hand it off to Rachel Schumacher, the director here at the Office of Child Care.
Thank you so much, Tricia, and hello, everybody. We are so happy to be with you this afternoon to go over in more detail some of the exciting provisions that were in the NPRM that we released and is currently out for comment around the country, and to really delve into one aspect of it, and I'll get into that in a moment. I want to start by saying, you know, this is one of 3 webinars. The other 2 will be on health and safety and on quality and consumer education provisions in the NPRM. this section, this webinar is around providing equal access to stable and high-quality childcare for low-income children. And I just want to say what an incredibly, what a sea change we are seeing now with this new law that Congress passed on a bipartisan basis in 2014, and with is what we have are about to explain to you in the NPRM around these topics and how exciting it is. I think if I can digress momentarily, I want to say thank you to everyone out there in the country who worked on these issues for the last multiple sets of years to really change the dialogue around what we would want to see for low-income children and families to have access to in terms of quality, to promote the stability of their access to those programs, and to really support equal choices for low-income families who rely on child care assistance to help them make good choices and access things safe and enriching places for their children, experiences for their children while they work or pursue education. And so this moment is an exciting one. It's one we share with many of you on the line and are really excited to delve into more today. I am, as Tricia said, the director of the Office of Child Care. I've had a great privilege of joining this team just over a year ago, and today I will be joined by my colleagues in the Office of Child Care who will be also explaining some of the provisions and who have been working very doggedly to unpack what was in the law passed in 2014 and had done this before I came on board, and really have done amazing work. So today I'm joined by Min Lay, Child Care Program Specialist, and Mary Sprague, also a specialist in the policy team here, who will be walking through some of the details and bear a tremendous amount of responsibility and much thanks from me for the long hours they've put in over the last year to try to shape up this NPRM and put it out on a very quick timeline so that you all, the public, on this call have it as an opportunity to review it and give us comments over the next set of weeks. So let me turn, I know we have a lot to do, so I'm going to minimize my introductory comments, although I could also get a little emotional and excited to just go on and on about the moment we have here. But you all know, this slide just gives you a little background, which I already went over, that we have recently celebrated the 1-year anniversary of the reauthorization of the Child Care and Development Block Grant, and we are using this webinar to summarize certain components of the proposed rule, even within the topic of equal access and stable, high-quality childcare. We're only able to get to some of the provisions because there's a lot of detail in the NPRM, so this is by no means a substitute for reading the full text, which you will see the link to on the bottom here. And let's move on to the next slide. This, as you know, what we're about to describe is the Notice of Proposed Rulemaking. And you know, NPRMs, I think when I came on board, I had to do a little cheat sheet for all the little acronyms that you learn when you work in the federal space. The NPRM is obviously a public notice of proposed regulations, and we are in a 60-day comment period, which will end on February 22nd. I'm sure everyone on this call is aware of that. Those comments will be reviewed, and we are hoping to have a quick timeline of finalizing this process in the summer of 2016. One thing we like to clarify when we talk about the law and about the NPRM, the NPRM's preamble is organized to focus on these 4 specific areas that are all really critical to improving and reforming the child care system in this country. And the one that we are focusing on today is providing equal access to stable, high-quality child care, as we've been saying over and over. The others are around protecting the health and safety, helping parents make informed consumer choices, and really enhancing the quality of the child care and child care workforce. And all of these things, the reason these things are the 4 that we really stress are because really the Congress's changes to the law the purposes of what CCDF, really is supposed to be have been very much changed in this reform. And the goals of improving child development and the goal of increasing access to high-quality child care for low-income children, those were added into the purposes of the CCDF program where they weren't there before. And it really reflects a change in the orientation of this program. It reflects a lot of folks coming, and researchers, advocates, and others coming, state leaders coming and talking for many years and making the case for the role that subsidy plays in helping families who are trying very hard to improve their financial well-being and provide for their children, or get a better education so that they can provide for their children at a higher level. If they're relying on child care, what is it that we can do to make sure that they have stable access to that, to care, and that they can access providers who are going to be able to really help their child be ready for school and to thrive and grow. So we have an opportunity here to really change the way the Act is written, the way the program works. It is now much more about child development and in hand with families and supporting parents' goals of their own. But it is no longer really a work support program. It is a program that focuses on supporting the success of 2 generations. Okay, so in this webinar, we're going to cover the following topics. We're going to start off with the continuity of child care assistance provisions. We're going to move on to really focusing on access and the way homeless families are able to access the program. We're then going to move on to the larger sphere of access around payment rates and practices and how that influences provider involvement in the program. We're then going to talk about how provisions would apply to tribes, and then go over the public comment process. So I am going to now turn it over, I believe, yes, I'm going to turn it over to Min. Min, take it away.
Okay, thank you, Rachel. Good afternoon, everyone. I'm Min Lay, as Rachel mentioned before. As she said, that we've been working on this issue for a long time, so I'm excited to talk to you about what we're doing with continuity of care, or continuity of child care assistance. We were very excited to see what Congress did and the actions that they took in this area, and we're excited to take what they put in the law and translate that into regulations that will help everyone implement this exciting new reauthorization. So as a reminder, like Tricia mentioned, these slides will be made available, so we're not going to bore you by reading giant blocks of text today, but we're going to hit the high points, and we have a lot to get into, so let's jump right in. Speaking of giant blocks of text, hopefully this is familiar. This is taken straight from the CCDBG Act. We thought it would be a good place to start by just reminding that Congress did establish a minimum 12-month eligibility period, and they really worked hard to put lots of protections around that period by considering families to remain eligible during that time and that they should receive assistance to really stabilize care for families. And what we've done through the NPRM is really try to put that into place and honor the efforts that they made on that front. So on the next slide, we're talking about ensuring that 12 months eligibility for child care assistance. So in order to keep that minimum 12-month eligibility period, we've clarified that that minimum period applies to both the initial and subsequent eligibility periods. We provide additional detail around what should be considered temporary. So what changes families would be allowed to experience and still keep their assistance. And then we also clarify that this would prohibit shorter authorizations, since allowing families to be eligible for a minimum amount of 12 months, but offering shorter authorizations would undermine that new eligibility period provision. As I said before, the law really tries to protect that period, so we've tried to distinguish between what is required of families during their initial eligibility determination and at the redetermination point, between that and what can be required to report during the eligibility period. So as is currently allowed, lead agencies can establish additional eligibility criteria. We just clarified that those would apply only at the initial determination or redetermination period. So the NPRM what clarifies that families are required to report if their income exceeds 85%, and also that if the lead agency chooses the option to terminate for job loss or cessation of job training or education status, which we'll talk about later, if the lead agency chooses that option, then they can also require the families to report a change of that nature. And then we also allow states the option of reporting contact information and things that would allow the lead agency to stay in touch with the family. Another point that we make here is that we do clarify that families must be allowed to report changes at any time, and that lead agencies have to act on information if it would benefit the family. We put that in place because we want to clarify we're trying to protect families from having to report all the time, but we don't want to penalize them by shortchanging them if their benefits could increase. So another area that we've talked about a lot internally is alignment with other programs. So we put language in the NPRM, and I hope that you do read it, that encourages alignment with other programs, and we give some examples, one of which is the concept of resetting the clock. So that if a family comes in for their eligibility and they receive their 12-month period, if they're supposed to go in for a redetermination with SNAP within that eligibility period, the agency has the option of resetting the clock at that point so that those eligibility periods are then aligned. We do clarify, however, that during this alignment, if there is information that's found through other recertification processes, that the lead agency can't prematurely terminate the family's eligibility unless it's that their income exceeds 85% SMI. So flexibility for working parents is something that we really emphasize a lot. The law requires that the processes for determination and redetermination take into account irregular fluctuations in earnings, and we discussed that at length in the NPRM. And then also requires that their procedures and policies ensure that parents don't have to unduly disrupt their employment, education, or training. We've heard lots of stories about families who have to take time off from work in order to go in and get their retain their assistance. So we really wanted to emphasize that. And the NPRM further clarifies that lead agencies are not required to limit their authorized childcare to the parent's work schedule or the number of hours. This comes into play when we talk later about child development. We really want lead agencies to think about what's best for the child and the family when authorizing care. So with that in mind, we're talking about the focus on children's needs. So the NPRM would require lead agencies to take into consideration children's development and learning and promote continuity of care when authorizing child care services, for example, what we just talked about. And we clarify that the protected services category, which has been in place for through the last regulation, that lead agencies can include specific population of vulnerable children in that category, and that the lead agency has the flexibility to define that. The lead agencies aren't required to do that, but it's something that we think is a really good opportunity to make sure that you're serving the most vulnerable population. So next up is continued assistance before optional termination. So this is what a lot of people refer to as the job search provision, but it is broader than job search because families aren't required to be doing a specific job search activity during this time. But what it says is that the lead agency does have the option of terminating assistance before the eligibility period ends if there's a loss of work or cessation of attendance at job training or education. What this requires is that if the lead agency chooses that, they have to provide at least 3 months of continued assistance to that family before termination. So through the NPRM, we've clarified that that period of continued assistance has to be provided at the same level. And we clarified that there's no requirement to collect documentation during this continued assistance. We know that families that fall into this situation have a lot on their plate, and the last thing we want them to do is have to jump through more hoops in order to stay on this. We also clarified that if by the end of the 3-month period the parent is again engaged in the eligible work, education, or training activity, then they should not be terminated. They should be allowed to play out either continue their eligibility till the next scheduled redetermination, or if the lead agency chooses, they could offer them an additional eligibility period. So next up is everybody's favorite topic, graduated phase-out. So the law establishes a graduated phase-out for families who at redetermination exceed the initial CCDF lead agency income threshold, but do not exceed 85% of state median income. So one result of that is that if your state already has initial eligibility set at 85% SMI, then you do not have to worry about graduate phase-out because you've already met the requirement. So we specify here that the lead agency, in order to meet the graduate phase-out requirement, the lead agency has to establish their second tier of eligibility at 85% SMI. So when the family comes in at redetermination, if they're between the initial determination threshold and 85% SMI, they should be allowed continued assistance. Now, there are two options that the state has. One is to allow the child to retain eligibility until the family exceeds 85% SMI. The second is to do that for a more time-limited period and extend assistance for a limited period of at least a year. And then we also clarified that while co-pays can't be increased during the standard eligibility period, if a family is eligible through graduate phase-out, then the lead agency can make adjustments, reasonable adjustments to help families transition off of assistance. So this is a point that we wanted to just offer some assurance to lead agencies who we know have some concerns about how these new eligibility policies will interact with program integrity efforts. So we clarified in a couple of places that these following situations are not considered errors or improper payments. So a child who meets eligibility requirements at the most recent determination is considered to meet those eligibility requirements for that period. And so if there are changes during the eligibility period other than the 85% SMI change, payments that are made to that family are not considered an error or improper payment. So minor changes in income wouldn't trigger any kind of error. And the second, and we'll talk about this more with homelessness, is that a child experiencing homelessness or is in foster care is permitted to enroll prior to submitting all documentation. So if they are subsequently found to be ineligible when all the documentation is put into place, any payments that were made during that initial period are not considered an error. Okay. So we obviously welcome and are looking forward to comments on the entire NPRM, and we encourage you to give us comments, positive or negative. There are places where we're specifically asking for comment because there are areas that we've been grappling with internally. So here's a table with some of those areas within this section. They include if there are additional circumstances under which a lead agency should be allowed to end assistance. Then also we want to know more about the impacts of the proposed graduate phase-out provision. On our CCDF reauthorization website, there's a full table with all the areas that we're requesting comment, and we provide the citations to make it easier for you and us when we have to and get to read through them all. So I know that is a lot of information, and we've been very much in the weeds on this end, trying to figure out how everything fits together. So we tried our best to come up with a visual representation of how all these new eligibility policies will fit. So this isn't meant to be a comprehensive or particularly nuanced vision of how every single eligibility system will work, but I hope this will help you wrap your minds around all this new information. So we're going to walk through this step by step. So let's say a family enters into, comes into lead agency for the initial eligibility redetermination. They would either be determined to be ineligible or eligible. If they are determined eligible, then they would be eligible for a minimum 12 months of eligibility and assistance until their next redetermination period. Of course, if there are insufficient funds, there may be some people who are forced to be put on a wait list. As you talked about before, Congress really tried their best to protect that 12 or minimum 12-month period. So there are limited exceptions to that. If the family's income non-temporarily exceeds 85% SMI, then they would be deemed ineligible, and the NPRM specifies that families do need to report if that happens. The other one, which we talked about, is the non-temporary loss of job cessation of job training or education program. So in this scenario, the lead agency has a number of options. One, they could allow the family to retain their eligibility until the next redetermination period. and consider them just as is. If they do choose to end eligibility, they have to offer at least 3 months of continued assistance before they can end the assistance, before they can terminate. Of course, as we mentioned before, if the parent does resume job training or education during this period of continued assistance, then the family should be allowed to retain their eligibility. So that is protecting everything during the eligibility period, and now we're going to talk a little bit about the redetermination point. So at redetermination, if the family's income exceeds 85% SMI or doesn't meet other eligibility criteria, they would be determined to be ineligible. Otherwise, if they meet all non-income eligibility criteria, that triggers a number of scenarios. One, if their income is under the initial income eligibility threshold, then they would be eligible, and that triggers another full eligibility period. If, however, their income exceeds the initial eligibility threshold, but it's still at or below 85% SMI, then there are a number of things that could happen. It would trigger the graduate phase-out provision, at which point they would go in for another at least 12-month eligibility period. However, as we said, with graduate phase-out, the state does have the option of putting a time limit on that. So if at eligibility, at the redetermination period, they come in and they've already received their graduate phase-out, if the state has chosen to put a limit on that, then the family could be determined ineligible at that point. So once it's all out here, I know it looks very hectic, but I hope that was somewhat helpful in explaining how all this works. And now we move on to improving access for children and families experiencing homelessness, which is also me. Again, Congress really worked really hard to emphasize the population of children and families experiencing homelessness and put a lot of new language in the statute. We really wanted to make sure that we drove the point home that we wanted to do whatever we can to help these families receive access. So the law requires that the lead agency have procedures to permit enrollment of children experiencing homelessness prior to completion of all documentation, and this also includes a grace period for compliance with immunization, health, and safety requirements. It requires training and technical assistance on identifying and serving homeless families, and specific outreach to families experiencing homelessness. Also requires coordination with programs working with children experiencing homelessness. And for the data nerds out there, very excitingly, it now requires lead agencies to collect and report whether a family is experiencing homelessness. And I know a lot of advocates are really excited about having that so they can see if we are having the reach that we hope for. Oh, okay. I just drank a large coffee before this, so I may be speaking fast. I'll try my best to slow down for my last slide. So for homeless provisions in the NPRM, we do add some additional provisions that defines homeless to be consistent with the definition in Section 725 of Subtitle 7B of the McKinney-Vento Act, and that aligns us with the Department of Ed and Head Start. We also require lead agencies to coordinate with other relevant agencies to help families who are receiving services during the grace period comply with immunization, other health and safety requirements, because we know it is important to ensure health and safety. And finally, we clarify that children experiencing homelessness shall be given priority for services. So I will now pass it back to Rachel to discuss equal access.
Okay, thanks, Min. So now we're going to turn to an issue that I think Congress also spent a fair amount of time puzzling over this concern, wanting to make sure that if we're paying for care that is with public dollars to help low-income families access child care, we would certainly want that care to be something that is healthy, safe, and promote the child development of the child who is actually experiencing it. And what are some ways that we can do that? And so one of the things that's really important to think about is all the policies that go into provider payment rates and practices of paying, how providers are paid. So it's not just how much, it's also how. And those types of policies, over the years, we've been able to look at research and really understand that they offer incentives or disincentives, depending on what they are, to providers to participate in the program. And for a long time, there's been this language about equal access, that we want that the program is supposed to be providing equal access to care for participating families. And so when Congress looked at this, and then when we spent time looking at it at the Office of Child Care, trying to think about how to clarify through the NPRM, and we spent a lot of time thinking about, what does this mean? How could we give this a little bit more clarity, given there's a new purpose about increasing access to high quality care for low-income families for CCDF, and that hasn't always happened in the past. Obviously, there are total financial reasons for that states are really struggling with, how much money we have and how far it can go around. But there's also things just about how the program is run that turned out to actually affect whether providers are willing to be a part of the system. And we would really want to get rid of those types of barriers and to encourage providers who are needing to have a certain amount of money in order to attract high quality staff, to keep those staff, and to provide all the services that we would want a low-income child to benefit from. So how do we think about that in terms of how the NPRM lays out the rules for states going forward? So the first thing that we looked at is the provisions are in the law that talk about equal access and what the lead agency in the state or territory needs to describe in their plan, their CCDF plan, about how they're going to do this. So the NPRM would require some new facts that states and territories would need to provide in their plans. It's a continuation, as I said, of a pre-existing piece in there around making sure subsidies are sufficient to ensure equal access. But there are some new wrinkles in the NPRM that we are putting out for comment. So you can see from this list, it's actually over 2 slides, and I'm just getting going on the first one, that the things that are in bold are the new provisions that are proposed. So one of the things that is new is that is actually in the law. The law allowed that states can set rates based on a most recent market rate survey or an alternative methodology. That's a new opportunity that was put in the law by Congress. What the NPRM clarifies is rates must be updated every 3 years, at least every 3 years. Another new provision is that the state or territory needs to describe in their plan how base payment rates support implementation of the health and safety and quality requirements actually included in the law and in the NPRM, which makes perfect sense that you would want the rate to actually allow families to access the care that is meeting the requirements. In addition, on the next slide, you'll see some more of the existing and new in bold provisions that are in the NPRM. So number 4 is how payment rates allow CCDF families to access care of comparable quality to care available to families with incomes above 85% of SMI. So this is an attempt to really clarify, this equal access provision. Over the years, many people have said, equal access to what? And so we are proposing that families should have equal access to comparable quality care for those families who have incomes above 85% of the state median income. The law also requires, and is now in the NPRM, that the lead agency takes into account the cost of higher quality care in setting their rates, that payment practices support equal access to a range of providers, and number 8, how and on what factors the lead agency is differentiating their payment rates. So they might be looking at geography, they might be looking at age of child, things like the type of care. Those are all things that would need to be explained in the plan. On the next slide, we get into more detail on the market rate survey or alternative methodology and how payment rates are going to be set by the lead agencies. So the NPRM will require that lead agencies, obviously they have the option of using the market rate survey or the alternative methodology. In either case, they will need to consult in advance with their state advisory council on early childhood education and care, sometimes called SACS by folks here, might be called something else in your state. that they also need to talk with local child care program administrators, resource and referral agencies, organizations representing caregivers, teachers, and directors, and other appropriate entities. Any state or territory looking at submitting alternative methodologies will need to submit that in advance to ACF for approval. And the other provision that is new in here is reflecting variations by geographic location, category of provider, and age of child. The NPRM also requires making widely available a detailed report with the results of the market rate survey or methodology no later than 30 days after its completion. And this is basically to promote transparency so folks in the state or territory understand how exactly these rates were derived at. The next slide is around family co-payments, which we know is another factor when you're thinking about providers wanting to participate in the system, parents being able to participate in the system, and how those things interact. Co-payments, rates, practices, all of these things mix up and affect what the family is able to access and experience. So some of the provisions in family co-payments that we want to bring your attention to are here in a list, and just pulling out a couple critical. I'd like to focus on, we have a provision that that co-payments not be a barrier to families. We are also, as Min mentioned before, saying that co-payments should not change during the 12-month eligibility period unless they're in a graduated phase-out provision. And so that's getting at, when we look at the term graduated phase-out, I know a lot of us looked at that term when it was first created and thought, what does this mean exactly? One of the things that we thought it could mean, and are obviously interested in comments in this public process, is graduated implied co-payments could change over that time. So family during that time has some opportunity to start to look for other care, but also take on over a period of time the increased cost of bearing more of the burden of paying for care. Also, there's a provision in this NPRM around the recommended benchmark for how much a family's co-payment should add up to. So in the past, we had set in a previous preamble the idea that the co-payment ideally wouldn't be any more than 10% of a family's income. And now in this one, we're proposing 7%, and that's based on national data from census that looks at families, what they're paying now. And on average, it's now 7% across the country. We thought that we would suggest that that would be a good benchmark for low-income families as well. Some other provisions I know folks are talking a lot about and we're welcoming comment on is the issue of charging above the co-payment and allowing providers to charge above the co-payment for the care that the low-income family is able to access. And we know that this is something we really struggled with, and we're interested in folks' comment. On the one hand, we're worried that if parents are paying above the co-payment fee, it really masks some of what they're really taking on in terms of their family income. It certainly makes it harder to judge whether they're paying less than 7% of their total income to access care. On the other hand, it might help them. Paying more might mean that some providers would be willing to take families that otherwise wouldn't. And so we're really struggling with this issue. And let's see, I said I wasn't going to do all of them, but here I am doing all of them. We also allow waiving of co-pays for families that meet criteria established by the lead agency. So that's in addition to what had always been there. Many states do waive co-pays for families below poverty or for children in protective services. And we also prohibit co-payments based on the cost of care or amount of subsidy payment. So moving on, because I think I'm running out of time here, we are looking at a set of new provisions around provider payment practices that would really help allow for providers to have more stability in this system. One provision around here is ensuring timely payment. So we did hear a lot about this. Congress heard a lot about this over the last set of years. So in the NPRM, we're proposing that a state or lead agency could meet this provision by paying prospectively prior to delivery of services or by paying within 21 days of receiving their invoice for services rendered. And we actually looked at some national data, what states are currently doing to set this proposal. The law also has provisions around delinking provider payments from children's absences to the extent practicable. And the ways in which the NPRM suggests and clarify that a lead agency can meet this include paying based on enrollment, providing full payment if a child is attending at least 85% of the authorized time, providing full payment if a child is absent 5 or fewer days, or an alternative approach that must be justified in the plan. We have another set of slides here around improving provider practices, payment practices and provider stability. Excuse me, that's sort of a tongue twister, Peter Pickle Pepper. All right, so these other provisions we want to bring your attention to. So the law says the payment must now reflect generally accepted payment practices. I'm sure you're familiar with that provision in the law. And this is something that in the NPRM we're saying, unless the lead agency provides evidence that such practices are not generally accepted, the two things here are paying on a part-time or full-time basis rather than sort of breaking it up into 15-minute chunks or hourly chunks, because that's not typical payment practices out in the world of private paying parents. Another component of this is requiring that we pay for mandatory fees that providers charge to private paying parents, such as registration fees. Additional provisions are around providing payment for any services that in accordance with payment agreement or authorization for services. And we also have some provisions where we will be interested in folks' comments around ensuring child care providers receive prompt payment of changes. We've heard stories about, the provider keeps providing care and didn't know that the family wasn't eligible, and then they end up not getting reimbursed for that, and that's a very difficult situation for them that can make them very unstable. And last but not least, we are suggesting that lead agencies have a timely appeal and resolution process for payment inaccuracies and disputes. Let me move on here really quickly. So we have a set of requests for comment. I'm not going to read them. We have actually an entire document on our website that lists all the areas in which we specifically ask for comment, in addition to just in general, where we welcome your comments. So I'm going to turn it over to Mary, who will walk you through how these provisions would apply to tribes.
Thanks, Rachel. Hi, everyone. I'm Mary Sprague. Before I really get into which subsidy provisions will apply to tribes, I kind of wanted to give a little bit of context. So as you all know, many of the provisions in reauthorization do not explicitly apply to tribes. So starting last winter in 2015, we held a series of consultation sessions through the spring and into the summer to talk to tribes and to learn about the potential impact that reauthorization would have on tribal communities. And one thing we heard over and over again is that a one-size-fits-all doesn't really work for tribes because tribal communities are unique. So in the NPRM, we're proposing a new framework for the tribal requirements. So under our current regulations, tribes receiving over 500,000 are non-exempt tribes, and they're subject to the majority of the CCDF requirements. Tribes that are receiving under 500,000 are thought of as exempt, and so they're exempt from operating a certificate program, and they're also exempt from the quality spending requirements. And we weren't really sure that that framework worked for tribes with reauthorization, especially because there's such a wide range in the allocations that tribes receive. So we're proposing 3 different tiers of tribal requirements based on a tribe's allocation size. So tribes receiving large allocations would be subject to most of the requirements. Medium allocations are exempt from operating a certificate program, and then small allocations would only be subject to a reduced number of requirements. So now getting into the applicability of the subsidy requirements. So tribes receiving large and medium allocations are subject to almost all of the requirements that we've covered in this PowerPoint, and tribes with small allocations have the flexibility to set their own eligibility requirements. I also wanted to point out one additional tribal-specific provision that we think adds a lot of flexibility for tribes. So the NPRM proposes to allow tribes the option to consider any Indian child eligible regardless of a family's income, work, or training status if the tribe's median income is below 85% of the state median income. And we think that this proposal will give tribes the flexibility to align their child care program with other tribal early childhood programs. So with that, I'm going to hand it back to Rachel to wrap up talking about the public comment process.
Thanks so much, Mary. Okay, so I think these slides are fairly dry, but they are very important information we want you to have because they are telling you how to comment and giving you some hints on how it would make it easy for us to process and understand your comments as quickly as possible given our incredibly fast timeline we have to finish this whole rule. So in terms of the comment process, you'll see here the specifics of how, the portal that we have available for that, and there's a lot of instructions there you'll need to follow as well. You can also mail them. That would not be as ideal for us. It would be great if you can submit them electronically. We really do look forward to reading these. We will need to be, analyzing them as quickly as possible, and having them electronically will be a lot easier. We also I just want to remind you again, there's a chart of all the ways in which we ask for comment that's available on our website. So we've mentioned some here, but there's others as well. So in the next slide, we talk about how specific it would be helpful for you to be very specific when you are doing your comments in terms of the agency name and all that sort of stuff. But more than that, we will be so thankful if you could be very clear about the page number, the column, and the relevant paragraph section of the Federal Register document when you are providing your comments. Please do that. That will be so helpful. Also, in terms of the comment process, we want to remind you that they will be posted for public viewing without any change. So others will be reading your comments, so personal information, all that type of thing will be publicly accessible. So be careful about what you put in it. On the other hand, we will accept anonymous comments, but you will have to indicate an NA in the required fields to make sure that we know that. We also want to remind you that any questions that you're providing here today, we're going to take them and look at them, but that's not the same. It does not substitute for providing us official comments that are on the record. So we will need to submit official comments to be able to be included in the comment process, to be analyzed by our crack team here and responded to in a miraculously short period of time when we produce our final rule sometime in this year. The other thing that, and here's the thank you and the information, more information about reauthorization. We do really appreciate everyone's attention to this issue, how much you all care very deeply about children and families, and how much you are committed to helping us produce the best rule possible by providing your comments. Please do realize that providing lots of letters that say the same thing is no more helpful than just providing one with a lot of folks signing on to it. In fact, it is much more helpful for us to have a consolidated letter and process. If you have a lot of folks that agree with you, please do go ahead and submit that together. It would be preferable for our process and helpful. We do, amazingly, have a little bit of time, perhaps because of Min's coffee, to get to a couple of questions. And so I'm going to pull out a couple of things here that we saw come in. One is around continued assistance. So we talked about that assistance has to be provided at the same level, quote unquote, when assistance is continued during the job search period. Does that mean the parent fee and copay has to remain the same, or could it be adjusted? That's a really good clarification, good catch. A family's copay can be decreased during the period of continued assistance, but cannot be increased unless during graduated phase-out. So that was a good question. Another question, speaking of graduated phase-out, is if a family exceeds 85% of state median income during the extended period of time that they have in graduated phase-out, would they be able to remain on assistance? And the answer is no. The block grant itself has a pretty strict rule that families' income cannot go over 85% of SMI at any point. That makes them no longer eligible. We say, we're using a little jargon here, so non-temporarily exceeding 85% of SMI is the term that we're using here, and let me just unpack that. Because there's also the other provision we mentioned that Congress put in around addressing that families have seasonal work, especially our low-income families, or shift work, and so their income might temporarily jump above 85% of SMI. It's really about their annual income or some process that the lead agency has to understand their income over a space of time that is relevant. So we don't want to be in a situation where they're in, you know, they're 1 week, it looks like, oh, that 1 week's earnings make it look like on an annualized basis they'd be over 85% of SMI. We certainly wouldn't want to penalize families for being in that situation. Another question that came in says, will there be any technical assistance to support new efforts around serving homeless populations? And yes, our Child Care Technical Assistance Network is working on supporting materials now, and we will be drawing on resources from other federal programs. We're always trying to coordinate with them. Many of you may be aware, and actually we just saw released this week a wonderful 50-state resource on homelessness among children around the country that came out through our Early Child Development Office's announcements. So if you haven't seen that, go look for it. It's a great new resource. And
we'll make sure it gets added to the OCC site as well.
Yes, they, of course, will be on the OCC site as well. But so we are very much, and have been for several years, working on the issue of homelessness and access to child care and early childhood services, and have some resources, and will continue to produce them as they are relevant to, in particular, these changes in the NPRM and the final rule. One other comment I saw come in said, how is it that you could pay prospectively for child care assistance in this program? Isn't it a reimbursement program? Well, actually, it isn't. The Child Care Development Block Grant has always allowed lead agencies to use contracts or grants as a way of paying for care assistance and providing for a slot that a low-income child who's eligible according to the lead agency's rules could qualify for. They do not actually need to only use vouchers or certificates or whatever the state uses a different term and to pay on a reimbursement basis. That is actually not a requirement of federal law, and it's one of the reasons we do not use the word reimbursement in this presentation. Instead, we have been trying to really use the word payment practices rather than reimbursement in order to make that point around the country that that is not a requirement. And the states actually have more flexibility in how they do these, put out the funding for child care assistance. And one of the ways that that approach can be really helpful is in building the supply of child care in low-income areas, or building the supply for children and families who are harder to serve or have higher costs to serve, like infants and toddlers. States, and many states do to a small amount, not their entire program, because they actually, vouchers are the way that most children receive their assistance. There are states that are using contracts or grants as a way to ensure care in certain neighborhoods or for certain children who have these special needs, et cetera, around the country, and is one of the things that we would expect to increase more given other provisions we didn't even get into today, but talked about in our previous webinar around the importance of building supply, which is another issue Congress addressed in this law. Let's see, how are we doing on time? Do we have any other questions that we could address? Any other questions, folks? States can no longer... No, so we have a question here about states can no longer use the federal poverty level for exit income threshold. Income is it below the 86th percentile? I think that with 85% of SMI is the standard that's used in the law. States often convert to the federal poverty level and express it as a federal poverty level. So that's just a matter of numbers and conversion, really, and just the way that we tend to refer to it is around 85% of SMI, since that's in the law, but federal poverty level can be converted into that level. It's just a matter of the income and different way of expressing it. So I think I'm sorry if we confused you around that. There's not a prohibition against talking about income and exit thresholds in terms of federal poverty level. It's just that the law uses the FMI as the way it talks about it. So
we did get another question about the slides. Just as a reminder, this webinar and the associated slides will both be published. We're aiming for within the next week. We do have to make sure that all of the pieces comply with the ADA Section 508, so that does take us a little bit longer because we have to make sure we have transcripts and everything. So we will send a note out to everyone who's registered for this webinar when they are available. When we have all of the webinars available, we'll make sure to send a note out to everyone in our contacts database. Everyone will find out. So keep an eye out for that. Like I said, we're aiming for about a week from now.
Okay. So any other comments from my colleagues, Min and Mary, or is there anything else you'd like to add?
I just thought it would be a good time to remind people that we have 2 more webinars coming up. One on Friday at 3:30 as well on health and safety, and then one on next Wednesday on consumer education and quality. So
if you need the information to register for those webinars, I believe you should be able to contact our I don't know if Kim or Laura can weigh in, but I think that there's a webinar email address associated with this webinar that if you send a note to that, we can send you the registration links.
All right. So unless there's anything you would like to add, I just want to thank my colleagues for pitching in today, and we got through a lot of information in a relatively short amount of time. We hopefully clarified some things. If we did also raise some confusing questions, we hope that we hopefully weighed on the side of clarification more than not. But there are other resources available, and obviously nothing substitutes for sitting down with a nice cup of coffee and a 450-page document that is the NPRM. And we really do thank you for all the work you've been doing to try to figure out the best way to serve children and families around the country, and we'll continue to partner with you. And we look forward to talking to you again in a couple days, and Friday, when we talk about health and safety. So thank you, everyone, for your attention. Have a great day, and we'll talk to you in a couple days. Bye.